and welcome to Bloomberg Quint. You're watching the fine print. In a major reprieve for Pricewaterhouse and its network firms, the Securities Appellate Tribunal has concluded that the auditing firm's role in the Satyam scam can at best amount to negligence and not fraud. In saying so, SAT has set aside SEBI's 2018 order that had barred 10 PW network firms and 2 individual auditors from auditing the accounts of listed companies for 2 and 3 years respectively. Briefly, here's what SAT has said. The Bombay High Court had defined the scope of SEBI's jurisdiction to investigate PW's role in the Satyam scam. The High Court had laid down that SEBI's jurisdiction would depend on the evidence. If SEBI concludes only some omission without any mens rea or connivance, it cannot proceed against the audit firms. SEBI failed to prove fraud against the audit firms and the 2 auditors. There is no evidence to show that these entities fabricated, falsified, or fudged Satyam's books in collusion with the company's management. SEBI's regulations on prevention of fraud and unfair trade practices can only apply to persons directly or indirectly dealing in securities, and an audit firm cannot be said to be dealing in securities. And for an entity not dealing in securities, SEBI's directions can only be remedial in nature. Preventive directions cannot be issued, and debarment, as per SAT, is punitive. And so the appellate tribunal upheld the remedial directions in SEBI's order, and that was a penalty of 13 crore rupees. Does this SAT order place an unreasonable burden of proof on SEBI to conclude wrongdoing on the part of auditors? And has it restricted the regulator's powers in the kind of directions that can be issued for market entities that don't strictly fall into the category of dealing in securities? To answer that, I have with me Bombay High Court advocate and former SEBI officer PR Ramesh and Umakanth Varottil, Associate Professor at National University of Singapore. Gentlemen, thank you for joining me here on the fine print. Uma, before we start discussing the implications of the SAT order, would you say that SEBI's hands in this case were tied to begin with, since Bombay High Court had said only if the regulator can prove connivance can it issue any directions against the PW network firms and the 2 auditors?
Yes, that would be right, because in a sense, SEBI's jurisdiction was circumscribed by the order of the High Court, and the High Court was very clear in saying that SEBI's powers will arise only if there are jurisdictional facts. So in other words, SEBI's powers are intrinsically tied up with the facts in the case. So unless the facts actually establish, it is not possible for SEBI to exercise jurisdiction. And there the facts being that mere negligence is not sufficient. It is necessary for there to have been a connivance or collusion or mens rea. So unless SEBI can prove that, it is not possible to exercise that jurisdiction. So in that sense, I'm not surprised by this outcome, because SEBI's burden was unduly high in being able to discharge, and SAT seems to think that SEBI has failed to discharge that burden. So in that sense, it's completely tied up with what the Bombay High Court has laid down for SEBI to do.
Okay. Mr. Ramesh, I'll come to the specifics in just a bit, but broadly in the context of what the Bombay High Court has said, and then that became the starting point for SAT to view SEBI's order, what are you making of this outcome?
See, how I would look at it is the Bombay High Court has distinguished between a SEBI-regulated entity and that entity which is not regulated by SEBI. So SEBI-regulated entity where you have a licensing and registrations, so SEBI can proceed in like typically suspending a license, cancelling and all. So that power, the Bombay High Court has said, lies with the CA Institute, and that's a different angle altogether. But when it comes to the like jurisdiction of SEBI as a person associated with the securities market, I think the Bombay High Court clearly said if SEBI is able to establish fraud, then naturally you can proceed against the auditor. So that way, it's I would look at this case as more of a lack of evidence rather than a lack of jurisdiction, because SEBI did have the jurisdiction, which is what High Court said, and that's how the remedial measure also could be taken. But to put it slightly differently, when you look at the angle of being associated with the securities market, so there are larger implications, and I think see, for example, if you say an auditor is a person associated with the market, and you have to prove fraud. I think this applies to any other person. Like, for example, if SEBI wants to take action against a director or against a promoter or anybody, I think the standard of evidence is that you have to prove the fraud. So we will come to that point, I think, going forward.
What do you think that this SEBI order means for its jurisdiction vis-a-vis the auditors of listed companies? What could be the potential consequences of the conclusion that unless SEBI can prove connivance or fabrication of books of accounts, mere negligence won't amount to fraud?
So again, it depends. I think what we have here is some kind of a fragmented regulation of the audit industry. So on the one hand, there is the Chartered Accountants Institute, which has jurisdiction over the accountants. Then in some cases, the Ministry of Corporate Affairs under the Companies Act also has certain oversight. And in this particular case, the question narrowly is whether SEBI has the jurisdiction. Now, basically, the issue is investors in the stock market rely upon the accuracy of the financial statements while they make decisions to invest. And the limited question before SEBI and SAT here is whether SEBI has the power to pass certain orders, because the conduct of the auditor has an implication on investor protection and the protection of the stock market as a whole. And here, it seems to be that SAT is now telling us that it is only when fraud can be positively and extensively proved that the jurisdiction of SEBI to pass preventive orders arises. But if it's mere negligence, or maybe even gross negligence, is insufficient on its own. So I think it kind of makes a distinction in terms of negligence or gross negligence on the one hand and fraud on the other hand. And in my mind, it actually lowers the standard a little bit for auditors in terms of the role that they play as far as the stock market is concerned, because SEBI can have jurisdiction only if they are able to discharge that particular conduct of being able to prove fraud. So SEBI's burden is very high in what SAT has told us, and conversely, the accountants or auditors' role or standard is slightly lower in terms of what we have been traditionally looking at from the securities market perspective.
Sure. I'll come to you for this point, Mr. Ramesh. Yeah. SAT has pointed out that the Satyam's management had devised a systematic scheme to circumvent the scrutiny of the statutory audit process. And merely because the auditors failed to authenticate the bank balances and the FDs independently with the bank doesn't make them guilty of fraud. In saying so, has SAT placed a very high burden of proof on SEBI, because the cases that have of late come to light have always been not of auditors actually conniving with the management, but negligence, omission when audit processes were being violated by managements.
See, that's exactly the point here. See, what I would like to say, when we start with the Bombay High Court saying you should have mens rea. So when you solve mens rea is that you should have an intention and you prove fraud. Okay, now. So that was the order in 2010. Subsequently, we have a sequence of orders in Raki Trading, Kishore Ajmera, then we have this Baldevbhai Patel. See, all these issues, when you say mens rea, you have to prove fraud. So what is the standard of proof you need? Whether it should be beyond reasonable doubt, or it's a question of preponderance of probabilities. SEBI has always been relying on a preponderance of probabilities, and the Supreme Court has upheld that is enough standard to prove fraud. Okay, now when it comes to this particular angle of an auditor, see, there has been a continuous negligence. Even if it is a negligence, it's not a negligence for 1 year. It's a series of continuing negligence. My view is that with due respects to the SAT order, SAT has not looked into the overall context of the securities market angle. It looks only at a role of an auditor as a auditor doing a books of accounts, you audit, and this is your role under the CA institutes, the accounting standards and all. But when you look at the overall securities market perspective, which actually there are simultaneous proceedings which have gone against the promoters and so many other entities. So if you look at the overall picture, I think the complicity of the auditors will show. So whether there is a preponderance of probabilities, which I think is very much there, and maybe SAT erred in. See, this is again another angle which SAT is. It's one of the first cases where SAT is saying that if you look at a person dealing in securities, okay, now see there are.
I'll come to the distinction that SAT has made, but
when it comes to
specifically
this,
on the burden of proof now on that SEBI has to discharge. Is that a fair burden for SEBI to discharge? Is that a fair burden to say that you have to actually prove mens rea and fraud, and you can't any longer rely on preponderance of probabilities?
I think it's not a fair rule, and also the Supreme Court has said that that sort of standard of proof is not required. So because the orders of the Supreme Court in Baldev Patel, which is again a front running, what SAT has missed in that, there are entities even in that matter and so many other matters which are not actually associated with the market. In the sense, they are all associated with the market indirectly. They are not directly dealing in securities. For example, there are independent directors. They are not dealing in securities, but you could be part of the, so you are complicit in the fraud. So therefore, if you look at a larger angle, then naturally auditors will get stuck there. And on the preponderance of probability, I don't think a strict proof is required in this type of matters, and that's what will actually turn events in favor of SEBI if they appeal to the Supreme Court.
Should they not have gotten rid of this handicap when the Bombay High Court order had come out, in sort of taking that to the Supreme Court to say that the scope that Bombay High Court has laid down for us, the regulator, has been narrowed down too much?
No, I think SEBI played it very smart because this is one of the very first cases where you are taking action against auditors, and what is happening is SEBI wanted them, because Bombay High Court has said there are two types. One is professional misconduct, you cannot do anything, but when it comes to something related to the securities market, and if you have evidence, you can take action. So what happened, Bombay High Court merely has said it's about a mens rea. Bombay High Court did not say that is beyond reasonable doubt you have to prove. It said even it could be on the basis of preponderance of probabilities, which is subsequently upheld by the Supreme Court. So I think the Bombay High Court gave scope for SEBI. It upheld SEBI's power, SEBI's jurisdiction on anybody associated with the securities market. After all, if you see, the auditors are being appointed by the shareholders, and the shareholders, the price formation in the market happens on the financials. And if there is a continuous omission and commission, so naturally the auditors will be held liable.
Okay. Uma, weigh in on this distinction that SAT has spelled out for those who are considered to be dealing in securities both indirectly and directly versus those who are not. Has this principle been laid down for the first time that SEBI can only take remedial actions against those who are not dealing in securities? And is this distinction on a firm legal ground?
Thanks. So just to step back a bit, as Mr. Ramesh said, I think the Bombay High Court laid down the standard of proof, but it did not really set out the burden of proof. So that will depend on whatever the law is. And the three decisions which he referred to from the Supreme Court are the ones that actually lay down the standard of proof, which is basically that this is not a criminal offense. This is more of a penalty that's civil in nature, and therefore it is not necessary to prove beyond doubt, which in securities market transactions is often quite too onerous. It is sufficient to prove it through a preponderance of probabilities. Now, what the SAT seems to have done in this case is it has distinguished these Supreme Court decisions on two counts. First, it has distinguished the Baldev case on the ground that this particular decision does not involve an entity that deals in the securities, which here is the auditor. And to my mind, I do not think there's any precedent very clearly laying down that. And what SAT seems to have done is picked a few observations from the Supreme Court decision in the Baldev case without really getting into the details of the issue or the objective and the reasoning. So what SAT is basically saying is, if it involves a person dealing in securities, then the burden of proof through preponderance of probabilities will apply. But if it's not a person dealing with securities, then it has to be through beyond reasonable doubt. Now, in my mind, this distinction is too technical and misses the bigger picture, because an auditor is never somebody who deals in the market. And if you take such a strict interpretation, then the auditor is always going to be subject to the higher burden of proof for SEBI, which SEBI is almost never going to discharge at all. So number one, I think the distinction seems to be on thin ice. And to answer your question, there does not seem to be a straight precedent on this, but SEBI seems to have drawn some observations from the earlier cases, although it seems to me to be a bit of out of context in this regard. And the second is, apart from the legal question or the standard, SEBI has also said, SAT has also said that SEBI had not proven on the facts of this particular case. So there's a legal question and a factual question. And the legal question, to me, if it is answered the way SAT has, will keep auditors out of SEBI's jurisdiction pretty much, because on facts it's always going to be difficult to prove beyond reasonable doubt.
So on appeal, should SEBI's, if at all SEBI takes it to the Supreme Court, should their case be that this categorization in itself is on shaky ground, and if you proceed from there, what SEBI has brought forth in terms of evidence will be enough then to find the auditors culpable?
Okay. So firstly, definitely if there's one legal issue which will go up to the Supreme Court if SEBI decides to do so, I think this will be an legal issue that comes up to the forefront, because this is something that needs to be articulated by the Supreme Court. And to me, the SAT decision seems to be going against the basic grain of the three Supreme Court decisions which lay down the burden of proof. As to your question on whether the evidence before SEBI and SAT is sufficient or not, I think that seems to be something which needs to be reconsidered. The way I look at it, the SAT has laid down a very low burden on the auditors, whereas SEBI in its order of 2018 has placed a very high burden on auditors, where they say almost gross negligence equals to fraud. But I think, to me, the answer lies somewhere in between. So I think the Supreme Court will have to lay down that standard, and it remains to be seen whether SEBI's evidence that it has so far will be sufficient or not. Certainly, it's not been able to establish the standard set out by SAT, but whether a lower standard will suffice or not remains to be seen. My own personal opinion is that the SEBI's order was also based on a lot of conjecture and trying to link up negligence with fraud, and that might just not be sufficient.
Okay. Mr. Ramesh, do you want to weigh in on some of the grounds of appeal that SEBI would probably, if at all goes to the Supreme Court, would like to bring up?
Yeah, I think the first thing is about a distinction between a person associated with the markets, a person directly dealing in securities. I think SEBI will have to raise that issue at the Supreme Court, because the way I have read the Baldev Patel order, it's that there are entities who are not actually dealing in securities. So the Supreme Court precedent is already there, but even if you are not dealing in securities and you are associated with the securities market, a preponderance of probability is sufficient. So this order has been ignored by the SAT order. So SEBI will be raising this issue. I think the other issue is that if you're going to have a standard which is beyond reasonable doubt, you have to prove. I think SEBI is going to have problems with not only auditors, you'll have a problem with directors. So because directors are not regulated by SEBI, you're going to have a problem with independent directors. You'll have to have a problem with promoters who are not dealing in security, but SEBI, in most of the cases, says they are complicit in the fraud. So this is going to dilute the SEBI's approach to regulation in a substantial way. I don't think that is the intention, because the same order, the Baldev Patel order, reads what is a fraud and what is SEBI's power in a very extensive manner.
Okay. SEBI had also barred 10 firms of the PW network, but SAT again has rejected SEBI's approach and said that, misconduct committed by a partner in one firm cannot make the network of firms liable. Do you agree with this conclusion?
I think that I will agree with that SAT order, because this is for the simple reason, if you don't have evidence against certain people, I think the order should not have been passed against entities who are not connected in the matter, because how will you prove? Because ultimately it's all the question of evidence.
Uma, do you want to also quickly comment on what you make of SAT's conclusion on the liability of the PW network firms as opposed to the particular firm which the partners who were the signing auditors on Satyam's books were associated with?
Yeah. There I tend to agree with Mr. Ramesh that I would be a little sympathetic to the network of firms in this particular case for a number of reasons. First, these entities are clearly a separate legal entity, so to speak. Each is a separate partnership firm. They only come together under a common brand, under some kind of alliance, but that may not be sufficient on its own. So to that extent, I think that's understandable. And the second is, to some extent, the concept of network has itself been well understood in the Indian context. So in fact, what it really needs is some kind of underlying rethink and reforms in terms of, do we want to allow firms with larger than 20 partners to be registered? Because unless we come up with some kind of radical solution, these problems are going to continue. And SAT's order is kind of a recognition of that problem, and to that extent I'm not completely surprised by that. It would have been really onerous on their part to try and bring other firms within the network to also share that burden or liability. But having said that, I think it misses one point, which is, if SEBI wants to come up with a prohibitive order, then there might not be enough of a reaction if you only prohibit that one particular firm, because the reason why you may have to prohibit them from acting over a period of time is also protective, not just punitive. So maybe to that extent, I think there are some lacunae in that, but SAT could not have done anything else on this, in my opinion.
All right, I'll leave it at that. And as both of you have pointed out, it's imperative for SEBI to take this to the Supreme Court to at least straighten out some of the legal principles that could prove to be problematic for the regulator in future cases of similar nature. Mr. Ramesh, thank you for joining us here on The Fine Print, and thank you so much for watching.